What families risk when they enter our family court system are loss of their children. They're at risk of losing their property. They're at risk, grave risk, of being bankrupted.
As long as there's money, there's a crowd, and until it's gone, there won't be justice.
I met a woman one time years ago, and my daughter was very young, and she told me that she had lost her son. And immediately I thought, oh, something's wrong with her. Maybe she's a drug addict or an alcoholic, or she has emotional problems, or she's unstable.
A mother to have lost custody is an outcast. There must be a real reason why she has lost total custody. And the pain in that I can only explain as a war-torn vet, because you will never get over that the very system that you believed would protect you is just a money-making business.
The abuse, physical abuse, verbally abuse, emotional abuse, financial abuse, start when I got pregnant. And then November 3rd, 1999, he put me on the headlock over a rice cooker. And at that time I said, you know what, I can't do this anymore. It's just too many hits. I can't handle it. So I grabbed the phone and I called 911. Within, I believe, about 3 minutes, two sheriff cars show up, and the sheriff took him to jail. Commissioner Sylvia Shapiro gave me 3 years restraining order against my ex-husband in 15-minute hearing. First custody trial, I submit several photographs of my child. He's bruised, big as a fist size. In the past, when he was a toddler, his private part was burned. How did he get that injury in the private part? I don't know. I don't know then, I don't know now. My son had been exposed to internet anal sex pornography. I report this incident to the court. Nobody listened. Nobody believed me.
When a child alleges sexual abuse specifically, but also lately it's become any kind of abuse, domestic violence or child abuse, and a parent asks the family court for protection from the other parent for that child, often the allegations are considered by the court or ancillary professionals in terms of parental alienation syndrome.
Parental alienation is junk science. Parental alienation was a concept invented by some fellow back east, and his theory was that parents could alienate a child from the other parent. It first got a lot of press or use with respect to abuse cases and in the criminal context. As a defense, someone charged with abuse would say, I didn't really do this, the other parent made the child say this.
Who do they blame? They blame me. Why? Because I report the incident. So they blame me, I report the incident. I'm delusional. Court mediator said, Yupa delusional.
They don't look for evidence of whether or not a crime occurred. They're more concerned with whether or not the child has been brainwashed or coached to believe that a crime occurred to them by a parent bent on ruining the life of their estranged spouse. Now that idea has many different iterations, it has many different names in family law, and it's kind of an idea that has been completely debunked and is laughed at in other contexts, but in family law it holds sway. It's the reigning paradigm. The way that PAS took hold as the reigning paradigm in family courts was that Richard Gardner, who was a psychiatrist, wrote a book called The Parental Alienation Syndrome, and then published it himself through his own publishing company, Cresskill Press, and then sent a copy of it out to each and every family court in America. with an offer that he could do training if they'd like to invite him to train on that. And that set up a whole new career path for him, because after that, he just had the initial investment of the publishing of the book and the mailing it out, and he did family court training for the next 20 years.
There are a number of courts that have not allowed parental alienation syndrome to be entered as evidence because they say it doesn't meet the Kelly-Fry standard or the Daubert standard of evidence. It's very controversial. It's not a diagnosis in the Diagnostic and Statistical Manual. It is a concept. It's a theory. It's not anything that's been proven.
He never said that his theories were based on any research, and when people challenged him, he agreed with them. They were just his personal ideas.
October 11, 2006, the father made a death threat to our minor son in a hospital setting that your mother gonna get killed. My son didn't tell me until dinner time, and I stay calm, I put him to bed. So next day, I took my son to the police officer, and the officer took my son inside the office and spoke with him privately. A few minutes, he came out and he told me, "Yupa, you stay here. I'm gonna issue you TRO. Judge Smith issued the restraining order right on the spot."
In 2003, the American Prosecutors Research Institute identified use of PAS as a deliberate means to obstruct prosecution of abuse cases.
We're seeing through many studies over the last 20 years that only 1 to 7.6% of allegations of child sexual abuse are maliciously fabricated. Unfortunately, judges assume, because of parental alienation's popularity, that 99% of them are fabricated, when in fact 92% of them are either true or based on a mistake.
The primary group of American prosecutors, all the DAs in the country, have acknowledged that PAS, which is completely unscientific, it's not accepted by legitimate medical or psychological organizations, it's a completely bogus legal defense of child molesters that's being used in family courts across the country.
It's still a big fad in Marin County, and that is a result of the mindset of the mediators, of the evaluators, of the attorneys who are using it. And keep in mind, these attorneys are using it for tactical reasons, not because they believe it's really occurring, because they know the judges will buy it.
The family courts loved the idea. They didn't realize at first that it wasn't based on any research. And they just thought, oh, this is an easy answer. It explains away these horrible cases that we don't want to have to deal with. Because if we think about whether abuse happened or not, we have to deal with evidence, we have to deal with trauma, we have to deal with horrible ideas, and we have to take a stand and say whether or not it happened. If we can simply dismiss it as some vindictive bitch on a rampage to ruin her husband's reputation, then it's easy to just punish the woman and make the whole thing go away.
The court abducted my child without any ground. I have the clean record. I am a licensed nurse. I take care of people, make sure my patients get well. I do teaching. I am a good mother. On the other hand, the father have history of violence. He have more than one restraining orders. The court gave him sole custody and placed me on 2 hours supervised visitation, 2 hours per week. What ground do they have? What evidence and fact do they have? They have nothing. They have nothing. They just wrote something, pulled something up from the thin air.
No evidence was presented to change custody. There was no reason for them to change custody. There was nothing presented that would even carry any weight to change the custody. The most outrageous part is you have a father who has raised these children from the time they were born, and then you take them away from the only stability that they've had, the house they were born into, and where they grew up. My children are no longer doing piano lessons. They're out of their religious training, doing organized sports, all the things that I put them into that will better them as people and serve them down the road have been wiped out. And they're essentially trying to take me completely out of my children's lives.
I went into court with the idea that we were going to bring two sides before a judge and they were going to come up with a reasonable conclusion to whatever, or the issue at hand. And I found out that was 180 degrees from what I was entering into.
The financial incentives are to keep these situations going. There's no financial incentive to settle the case. The judge keeps his job. The evaluators make a ton of money. The attorneys for the minor and the family court attorneys are guaranteed payment for, if the child's 3 years old, for the next 15 years. Because they never settle. These cases never settle.
If a child is placed in unsupervised visitation or full custody with the person that they've identified as the perpetrator of abuse, you know instantly that their protective parent is never going to just walk away and stop fighting for their safety. So there's automatically going to be a need for an evaluation. There's also going to be a need for a special master because it will be a litigious case and there won't be enough time on the court's calendar to deal with it, so they'll refer it to special master or force the parties to stipulate to a special master. Then you will have the special master typically suggesting that each party bring in parenting coaches, parenting coordinators, therapists for each party that will work with that special master. And suddenly, all these evaluators with alienation expertise have this opportunity to make gobs of money.
Nearly 5 years later, I'm still fighting for my children when my children have told everybody involved with this case, we want more time with our father. We love our father. Here are these people that are supposed to be neutral, unbiased people. And they'll come back to the courts and say, well, you know what? The father, he was the one that coached them into saying that.
The fathers who are trying to protect their children are every bit as perplexed and distraught as the mothers, because they're trying to protect their child from a mother who's having a variety of problems. They are labeled with parental alienation syndrome also. They have the court professionals move in exactly the same way.
As a parent, the only thing you want to do is protect your children. And this legal system now has put me in a place where I have no power. They put the power in the hands of the psychologist, the kid's attorney, the evaluator, and your role as a father is reduced, and your kids look up to you for guidance, for leadership. You're their hero, and you're not able to help them. That's a tough position to be in, especially now when you're out of money. I mean, where do you go when you've extinguished all your resources financially, and they've got to a point where you're powerless as a father?
There's a pattern to the cases. What we found is we can finish someone's sentence when they call us. We know what the next step in the pattern is. The abuse allegation arises. The alleged abuser goes to family court with the high-priced and very aggressive attorney. The plethora of people are involved. The money is systematically stripped from the protective parent. At that point, the professionals who are working with the child work together in concert. They even write that they're working in concert. And they all seem to support the alleged abuser. And the custody is then switched.
During the first custody trial, the court mediator failed to follow the local rules and the law. She broke every single rule in the book. She doesn't read the file. She doesn't read the pleading. She doesn't know the history of, my case.
Family court services mediators are supposed to know the law and know the procedures. And they don't. I don't know what they're teaching at the Judicial Council classes, but it sure isn't the law because they don't know what they're doing.
Mediators only spend a few hours at most with a family. they are not trained to be doing these kinds of investigations. They're trained as mediators to try to bring people into agreement.
You try to work out your issues, and if you don't, the mediator can make a recommendation to the judge about what he or she thinks should be the custodial status of each parent.
Well, that completely thwarts the entire idea of coming together and trying to work out an agreement between two parties.
And the real problem is that mediator ends up deciding your case. And that's not how the system is supposed to work. And so when the mediator decides your case, whoever loses is, quote, disgruntled, and they should be not because of the outcome, but because they never got a trial.
I felt at the time that I agreed to joint custody that I really did not have a choice. I knew that the father would make life very difficult if I didn't agree to joint custody. And I did want to try. It's just that there were so many problems since the moment he found out I was pregnant. So we actually tried a couple of overnights, and she was suffering from a yeast infection that only got worse after the overnights. And shortly after she had an overnight, I took her into Kaiser, and she not only had the yeast infection, but she had vaginal discharge, and she ended up with yeast on her tongue and around her rectum. And I didn't want to believe that anything was going on, but it wouldn't go away. And eventually she started talking about the hole in her vagina. Eventually, when she was old enough to talk. The evaluation basically was to see if there were any problems. These problems that I was reporting to CPS. It took about 6 months to complete this evaluation. The evaluator interviews the child and the parents, and in this case, the grandfather as well.
The evaluators are the ones who most frequently recommend that the child be placed with the very person that the child has identified as their abuser.
The first day I met the custody evaluator, I had this overwhelming feeling that she had already sort of made up her mind about this custody evaluation. My daughter began to talk about things that had me very concerned, which I reported to the evaluator. And one evening, she took a necklace out of my jewelry box, and right before taking a bath, she was naked on the floor and put my necklace up to her vagina and said that the snake goes into the hole. And on another occasion during the evaluation, we were getting her ready for a bath, and she was sitting on her knees in the bathroom and began to bounce up and down on her knees, and she had a tight fist as if she was holding something. And I said, well, what are you doing bouncing? And she said, I'm on his lap. And she said, I have to hold the snake until it dies. And she still had the tight fist as she was bouncing up and down. And at that point, I thought, okay, this is just not making any sense at all. And each time I would I would call the evaluator to let her know what was going on.
The evaluators were all to be trained in child sexual abuse so that they would have better training, they would have more expertise, and they had very specific rules and laws to follow.
Unfortunately, what happened was the same parental alienation trainers who were training court professionals in parental alienation just changed the name of their course to the new child sexual abuse training and trained basically the same misinformation.
After a short time, the evaluator did a home visit at my home and the father's home, and apparently the father and the grandfather, my daughter's father and her grandfather, either went out on their property or went and purchased a snake to make it seem like my daughter had a pet snake the whole time. The evaluator, when I met her next, she said, see, they're just into nature, and this is basically all your imagination. And I said, well, really, tell me when did the father get the snake for my daughter? And she said 2 weeks ago. And I reminded the evaluator that this report was made to my attorney and to CPS six weeks prior. So at that point, she got very flustered and very upset and very angry with me, and told me that it was just my imagination, that I was imagining everything.
Many players in the psychological mediation and legal process can become enablers of the abuse. I don't mean purposefully colluding with the abuse. That's a whole area we can also talk about. But inadvertently, almost subconsciously stumbling into becoming a colluder with the abuser. Not understanding that the person being abused is bringing valid information into the courtroom, and that person is being found not credible while so doing. It's terrible what's taking place. It's heartbreaking, it's sad.
The evaluator eventually issued a report, and the report didn't really make sense to me, but basically said that I was a danger to my child and that my child should be taken from me. And given sole custody to the father.
I don't think I have ever seen an evaluation or a mediation report that followed the laws that are on the books and the rules of court. I don't think I've ever seen one, and I've seen quite a few of them. The court orders counseling for the children, and sometimes, and particularly in Marin County, there have been a number of cases in which the counselors are aligned with the abusers and basically spend the counseling time saying how great the abuser is and how awful and crazy the mother is.
Attorneys know who these therapists are. Every county has 2 or 3 or 4 of them. You can go into court. The judges think they're wonderful, only because what do the judges know? They see them all the time, you know. And they go, I think the children need therapy. Well, you know, so the judge says, well, I'm going to order therapy. Can't hurt them. What's wrong with you that you don't want your kids to go to therapy? I'm going to order the kids go to therapy. We want them to go to Dr. So-and-so. Well, that's fine. I know Dr. So-and-so. He's in here all the time. He's really great with kids. Dr. So-and-so. Now you've got the kids going to Dr. So-and-so. The parent who is recommending Dr. So-and-so is the one who brings the kids to Dr. So-and-so and spends a good amount of the kids' time telling Dr. So-and-so what's wrong with the kids, what the other parent did, and so on and so forth. And then when it comes time for trial, it's Dr. So-and-so who comes in and says, this is what's going on with this family.
What they always say is, those are mental health professionals. They know much more about children and what's best for kids than we do. I just make decisions based on facts here. That's my expert. They'll advise me. But there's no oversight as to whether that expert has any expertise in the area of child sexual abuse or child physical abuse or domestic violence.
I have a case where a child was ordered to go to therapy at age 3, and 4 years later, these kids were still going to therapy. This kid had been in therapy longer than it had been alive. This kid didn't have to remember what happened in his childhood and tell the therapist about it. The therapist was there. You know? I mean, this is the level of insanity that goes on, and it's perpetrated by attorneys and by judges. By attorneys for tactical reasons, and by judges because it makes their job easier.
Much of the money comes from the litigants. That's the chilling part of it.
It's a business. It isn't where we're dealing with human people's lives. It's a big business. It's a money-making business that you're having people earning a big living.
This should not be a money-making industry. And we should not have profit linked to representing people who are undergoing this process.
All these people that are making hundreds of thousands, millions of dollars statewide off of the whole family law machine, they want the court to make those orders because those orders are what get them paid, and it's the reason for their existence.
So people in counties like Marin can pay $50,000 or $60,000 for an evaluation.
That's money. That's money buying something we label as truth and justice, where it's not money buying truth or justice. It's money buying, in some cases, lies, really damaging lies with long-term consequences.
There is something very, very unethical going on, at the very least.
They may utilize an expert who they know is going to come up with a result that they want. They're going to use a mediator who they know is going to come up with the result they want. They're going to use a child's attorney who will not investigate, and thereby they'll get the result they want.
And they say, hey, we're going to be working together for many years. You take care of me, I'll take care of you. I'll send all my business your way. And they have a little, the cronyism and the friendship in what goes on, what they actually keep from the courts and what they put in, and what really happens are two totally different things. They will do anything they can to make the ruling go in the way of the person that got them that job or they have that friendship with. There is no, the children's best interest is never even considered. They just do what works best for them, and they keep it in their little group.
It's who you know and how much money you have. It doesn't have anything to do with the law. It doesn't have anything to do with justice.
We recently had, in a cross-examination, one of our mediators talked about how she had talked to minors' counsel, but Family Code Section 216 forbids minors' counsel to talk to the mediator except under very explicit circumstances, and she admitted those circumstances did not exist. But the amazing thing was she was completely unaware of Family Code Section 216 prohibiting her from being able to talk to minors' counsel. She said, we do it all the time here in Marin.
We have mediators in Marin County who flat out lie in their reports and have been caught at it by the appellate court, and the trial courts have been reversed because of it. Well, they're still working in Marin County, and they're still writing reports, still making recommendations.
Marin has one of the more unique reputations in that Karen Winter came and did an investigation into the Marin court, and the information that came out of Marin was just hair-raising, absolutely hair-raising.
Certain names came up in the report, therapists, attorneys for children, and it just so happens that my ex-husband's attorney was mentioned in that report. Also, the attorney for my daughter was mentioned in that report, and the judge that was on our case was mentioned in the Karen Winter report. And at that point, I just felt that there was nothing I could do for my daughter. That if this was going on in the family court, that there was just no way to protect her. I felt like I was at the end of my rope. I couldn't help my daughter. So one day I decided that I had to leave. That I had to leave our home and our family and just take my daughter and protect her. And for 3.5 years, we lived a very different life.
Well, my son had to do this board, and he did. When I went to back to school night, I knew nothing about it because I hadn't spoken with him. And I read it, and it says, meet my hero, and it says, my dad. My dad inspires me to do everything I do. Sports is just one of the many things he helps me with. He is always there when I need him. He is my inspiration. It's got my picture in there. You may lose the battle because everybody else will say whatever they want. But in the end, I'm going to be able to look at my children. I'll look them in the eyes and say, you know what? I told the truth from point A to point B. It doesn't necessarily make you the winner in the court, but you're going to be the winner in life.
The complaints about Marin County have gone to all levels, starting with the judges, the presiding judge, the court executive officer, the Commission on Judicial Performance, the Judicial Council, the newspaper. All avenues have been exhausted. So who ultimately is in charge of our courts? It's Chief Justice Ron George. And I think at this point, having watched all avenues be exhausted, I say, Chief Justice Ron George, what are you doing? Why aren't you fixing what's going on in our courts? You know about it. Why aren't you doing anything?
But his reaction was, we're concerned about the public's perception. And when bureaucrats are concerned about the perception of the people they work for, what they're really saying is, it's not my fault. We don't have any shortcomings. We haven't done anything wrong. It's just the way they're seeing us. We have to get, our PR needs work.
I've worked in large bureaucracies all my life. And what I've found is that if the top leadership is competent and ethical, then everyone from that point on down to the janitor is also competent and ethical. If, on the other hand, there's any foul play or corruption or lack of ethics at the top, that too trickles down.
Their credibility is everything. And it isn't about how the public perceives them. It's about reality. And when they start hearing these complaints coming over and over again about the same things, rather than circling the wagons and sending their court administrator out to make some public statement, or their court administrator out to insult somebody with a dismissive, letter to the editor or whatever, that they're a disgruntled litigant or this or that or the other thing, they really need to say, hey, have we got a problem here?
The biggest tragedy in the whole state of California, that when a mother has exhausted all remedies to protect her child through the court system, and she finally does something as dramatic as fleeing with her child when it's clear that the child will be placed or has been placed with the molester or the identified molester, she's hunted. It seems like more effort is put into hunting this mother who's trying to protect her child than in finding criminals who are battering and molesting and raping people.
In 2004, January of 2004, I was arrested. They located us and arrested me. I went to jail, and they took my daughter. And without even assessing her, they gave her back to the father and the grandfather. And I stayed in jail for approximately 5 months. The family court judge at the time called all that evidence, all the information, frivolous. But yet that same evidence was allowed into the criminal court. We had a trial with a jury, and we were able to bring out the evidence regarding my state of mind and the reason why I left, basically. And the jury found that I was innocent, completely innocent. So they acquitted me. I think they really got that the players, the therapists, the attorneys, the judge, CPS, the sheriff's department, and the DA, none of them were really looking out for my daughter. And so I was put in a position to be the one to protect her. Now looking back, I realize it was not the answer to our problems. I would never, ever recommend leaving with your child without following a legal procedure. This only made things worse for me and my daughter. Going through the Marin court system has absolutely destroyed my relationship with my daughter and any chance of being a mother to my daughter. And I just hope that they haven't destroyed my daughter.
No one will fix it until the people who are making policy decide to fix it. And they're not going to decide to fix it until pressure is brought to bear on them to fix it. And that pressure has to come from the public. It has to come from the press. It has to come from our elected officials. It has to come from the oversight entities. It has to come from law enforcement.
It is a big, ugly, awful, incredible story that people don't know what to do with that. Just like those big stories that when there was finally a change, it was that there were enough people, or it was made big enough that more people took an interest. Just like global warming, just like the Catholic Church.
The people that I talk to across the United States, they say that each state has its judge, individual rogue judge, or its individual rogue court, or the whole court system is a mess, does not protect children. So it's a national and an international problem.
I would say we're seeing an emergency here. When these children are being damaged, they're treating like throwaway kids. They're disposable. Their welfare is disregarded entirely. The courts should not bear this burden by themselves, nor should any single mediator or profession. It's too serious.
What we believe and what we've suggested to the legislature is to have a multidisciplinary panel look at these cases for a second look to see if the child is safe. You know, I have no other agenda than that.
I think at least 5 different individuals from several different walks of life must review a decision about parental alienation, about child abuse, about custody, about domestic violence, especially when domestic violence exists.
There are many, many Californians who would welcome and cheer a sponsor for a bill who would implement judicial performance evaluations. Enough is enough. We need to have oversight, and we need someone courageous enough to say, look, the Judicial Council, you want your $3.9 billion budget. Okay, but let's implement judicial performance evaluations too, so that we know, as we're funding your requests, we know that your judges are following the law. We know that the public is being served by our courts. We know which courts are problematic, and by the way, what are you doing about it? And that is what judicial performance evaluations would provide. That's responsible government. That's the duty of our elected officials to make sure that the citizens are protected.
I love him so much. And when I first saw my son, during the ultrasound at 3 months pregnant, and I promised myself that I'm going to be the best mother that I can be. And I don't know how could I love somebody so much, the person whom I never meet, and I love him. And the court had took away my love.